SJC-13864, MD Zafar versus Massachusetts State Lottery Commission.
Okay, Attorney Tretyakov. Thank you.
Thank you. Good morning, Madam Chief Justice, and may it please the Court. Konstantin Tretyakov, Assistant Attorney General on behalf of the State Lottery Commission. The hearing officer correctly determined that the transcripts of sworn trial testimony before him constituted reliable hearsay that established by substantial evidence that the plaintiff had raped his former wife. And hearing officer, based on that factual determination, also correctly applied the regulations of the Lottery Commission to determine that the plaintiff's moral character was deficient and that issuing him a license or a privilege to sell lottery tickets in Massachusetts would not be in the best interests of the Commonwealth, the general public, and the lottery. I would like to start with the evidentiary issue first. This court stated in Cavell that substantial evidence can be based on hearsay evidence alone, as long as hearsay bears substantial indicia of reliability. And those indicia include that the hearsay is based on first-hand knowledge, that it is consistent, that it is corroborated by other evidence, and that it is given under oath. All of these criteria are easily met in this case. Just like in Cavell, the testifying witnesses before the hearing officer included the agency investigator and the plaintiff. The victim here, just like in Cavell, did not testify. The hearing officer considered the transcripts of the victims and other testimony at trial of the plaintiff who, like in Cavell, was acquitted of the underlying offense. The hearing officer, just like in Cavell, heard the plaintiff's testimony, did not credit it, and instead credited the testimony of the victim. So all we are asking the court to apply in this respect is basically to apply Cavell to the facts of this case and conclude that the decision of the hearing officer was supported by substantial evidence. Unless the court has further questions regarding the evidentiary ruling in this case,
you address the SJC case that your brother's going to rely on when he stands up, which is saying that when you've got a he said, she said case, we want you to make a credibility finding based on actual testimonies. I take it Cavell did not address that case, right?
Your Honor, Cavell
did Cavell also involve a child? I can't remember. Is Cavell a child witness case, or I just don't remember?
Yes, I believe it was an underage victim who was the plaintiff in Cavell was the stepfather of the victim. It was
a very young child, right?
I am not sure about the age, Your Honor, but I believe the plaintiff was underage in this case. And in Cavell, the court did address the prior cases, the city of Salem, for example, that my brother is relying on and the Superior Court judge relied on, and basically said that what these cases stand for is the proposition that where there are witnesses testifying at the administrative hearing before the hearing officer, then the parties are entitled to someone who was present at the hearing making credibility determinations, but that does not apply here. Well, it partially applies. The plaintiff testified before the hearing officer. Hearing officer heard him, did not credit the testimony. That was squarely within the authority of the hearing officer to make that decision. But the victim undisputedly did not testify. And even some of the early cases that the Superior Court cited to, for example, the Dodd case, it has, I believe in footnote 4, it acknowledged that this was an unusual case and normally the cases can be decided on transcripts. So this is, again, what we are asking the court to do here. Unless there are further questions on this issue, I would like to turn to the issue of statutory interpretation. And here, the plaintiff's argument is based on a single word, and, in General Laws, Chapter 10, Section 27, and the plaintiff is basically asking the court to read that statute conjunctively. The plaintiff's argument is unpersuasive for several reasons. One is selling lottery tickets in Massachusetts, it is a privilege. It's not a right. It is heavily regulated by the State Lottery Commission, who enjoys this broad discretionary authority over the privilege.
But how broad can that be, though? Because you've got the two parts of Section 27, right? So you know that you don't have the first. Right?
Correct.
Because he was acquitted.
Correct.
So when you start getting into how broad this can be, I mean, you could see that it could be used in a way to be discriminatory, to have absolutely no shape at all, when what's good moral character, right?
The opinion of the director.
Exactly.
By the plain language of the statute.
Right.
Yes, Your Honor. So the statute overall, the statutory scheme, if the court looks at other sections of the statute, for example, Section 24, the lottery's power to enact and revise regulations which are as necessary as they are to perform the functions of the lottery. Section 26, director shall license as agents to sell tickets such persons as in his opinion will serve public convenience. And then we have Section 27, which says that the director may refuse to issue a license to a person with a felony conviction whose moral character, in the opinion of the director, is also deficient. So if the court agrees with the plaintiff, let's assume for sake of argument, and says that this should be read conjunctively, what the statute says is, in this limited circumstance, when someone before the director who is applying to get a license to sell lottery tickets has a felony conviction, the director also should look into the moral character of that applicant, because the conviction, which makes sense, because the conviction may be from 25 or 15 years ago, and the applicant may have really turned their life around during that time. So to ensure that the factors based on which the application is decided are contemporaneous, the director should look also at the moral character of the applicant, and then, based on that, determine whether or not to refuse to license that applicant as an agent to sell lottery tickets. But it would be illogical to conclude from that one specific example that the statute gives that the director may not look at moral character to determine the suitability to sell license.
Is the saving grace here that there was a hearing, that Mr. Zafar was given a hearing?
It was one of the saving graces, Your Honor.
Well, I'm asking because if there were not, and you just say that just a cold read of the transcript would be enough?
Your Honor, going back to your earlier question about sort of the guardrails between this, around this discretionary authority of the director, of course there are hearings. The regulations and the statute afford actually two levels of hearings, such as occurred here, the director level and the commission level. At each of the hearings, the burden to show, at least by substantial evidence, although the hearing officer here applied even the higher burden, the preponderance of the evidence, to demonstrate the relevant facts. So these are definitely some of the guardrails. So answering your later question, Your Honor, yes, this is one of the saving graces here. But even assuming for the sake of argument that the plaintiff is correct here, it would lead to illogical results, because imagine someone with, let's say, 15 convictions of petty larceny under $1,200. That's a misdemeanor. Clearly not good moral character, because that person is proven beyond reasonable doubt to be repeatedly stealing. Under the plaintiff's logic, the director would be obligated to give that person a license, because despite the fact that the moral character is lacking, there is no felony conviction. So the license must be issued. So this would not only thwart this broad legislative objective to endow the lottery and the director with this broad gatekeeping authority over licensure, akin to what perhaps the Alcoholic Beverages Control Commission has over licenses to sell liquor in the Commonwealth, but it will also lead to those absurd results. So
is that where Judge Halal went wrong?
Pardon me, Your Honor?
Is that where Judge Halal went wrong?
Your Honor,
Substituting his view?
Your Honor, yeah, thank you for anticipating what I was about to say, Your Honor. In that here, the lottery reasonably interpreted the statute, and while I understand that the review of statutory interpretation is de novo by this court has also said that it accords some deference to reasonable interpretations of statute by the agency who is tasked to enforce it, which is what the lottery did in this case. So unless the court has further questions, for all these reasons, I will ask the court to affirm the decision of the Lottery Commission.
Okay, thank you.
Thank you, Madam Chief.
Attorney Howard.
Thank you, Your Honor. Good morning. May it please the court. Jason Howard on behalf of Mr. Zafar. Your Honor, the hearings examiner made errors of law and made errors in the application of the substantial evidence criteria, and Judge Halal can be affirmed in his motion on any of the three grounds that we raised in our brief. Focusing on the statute, Your Honors, focusing on the statute, it is fundamentally clear that Mr. Zafar was convicted of no crimes, felony or misdemeanor. Nevertheless, the Lottery Commission somehow got the transcript of his trial, and the investigator presented that to the director level hearing as well as the commissioner level hearing. Whatever reading that these individuals did, it is fundamental that my client was not convicted of a crime. He was not convicted of a felony. He was not convicted of a misdemeanor. He was not convicted of anything.
Where does that get you? I mean, I understand all that. That's a fact. But assume we were to agree that the regulatory authority is not limited to withholding licenses only from people who have been convicted of felonies, right? Because that does seem like an extreme understanding of the statute to say anyone can get a license unless they've been convicted of a felony, right? So if that's not the construction of the statute that we come up with, then the fact that he was acquitted doesn't get you where you want to go.
So in response to your question, it gets me the following. The hearings officer, the lottery, is relying on Section 27, convicted of a felony and of deficient moral character. My position is that if you are not convicted of a felony, we don't then proceed to this whole consideration of whether or not Mr. Zafar is a good or bad guy. Be that as it may, I understand that individuals can be accused of crimes. If they are accused of crimes and they are afforded an appropriate hearing where evidence is presented and there's a finding by a preponderance of the evidence that the gentleman committed the crime, then it falls under the earlier language of sections 26 and 27 that talk about decisions made in the best interest of the lottery. Cases interpreting best interest, for example, I cited Gurry versus public accountancy. The gentleman was a CPA. He was working as a treasurer for a company. He was embezzling from the company. He was convicted of no crime. And he made a vagueness challenge, said, hey, you can't punish me. I didn't do anything. No, your behavior that was determined by a preponderance of the evidence at the hearing shared a nexus, a reasonable connection with the profession that you were trying to engage.
So is the problem here that they withheld the license on the basis of Section 27 instead of Section 26? That they could have come to this result? Because let's assume you lose on the evidentiary question, all right? And the hearing officer could determine that this was reliable hearsay, decide to credit it on the papers, decide to discredit Mr. Zafar, who testified live. Let's assume, just accept all of that for this question. Is the problem here that they decided to withhold the license on the basis of Section 27 instead of Section 26? Could they have done it if the hearing officer had made the same credibility determinations? I understand your statutory argument to be then they could have withheld the license under Section 26.
No, respectfully, no. I'm not saying that they just picked that the hearings officer picked the wrong statute. Because if the hearings officer was relying on Section 26, the lottery would have had to have made an additional showing to the hearings officer and to the lottery, and the lottery would have to have found by substantial evidence that the accusation bore a nexus, a connection with the idea of selling lottery tickets to the general public.
And he did make that finding at the end. He says, a person of who's committed rape is antithetical, which is his finding. I understand you dispute it. I'm just trying to find out where your statutory interpretation gets you, because it's the problem that they relied on 20. In other words, with all the factual findings made, I'm trying to figure out, I'm worried that your view of the statute leaves the commission no place to go on these facts. Under which section, assuming that the hearing officer's findings are accepted, in your view, would the statute permit withholding the license?
With the facts that the hearings officer found, my read is that the statute, whether it's section 26 or 27, would not have support and does not support the denial of Mr. Zafar's.
So there wouldn't be, regardless of these facts?
Correct.
Okay, now
Yes.
that may undermine accepting your statutory understanding. Because that would be, right?
I disagree. The hearings officer, footnote 11 of his opinion said that he was not finding that there was a separate and independent basis, in reliance on the regulation 213 subsection 3, which is a derivative of section 26. But his finding was a period of stepping stones. It wasn't an independent. He found a rape had occurred, therefore not good moral character, therefore not in the best interest because he's not of good moral character. My point is that under section 27, the hearings officer was statutorily precluded from considering what is good or bad moral character in the context of the Lottery Commission, and therefore saying that it's not in the best interest of the lottery because someone is of deficient moral character, I suggest was inappropriate.
So, and under 26?
Under 26, there's no with respect. And I understand the accusation, but with respect to the Lottery Commission's large remit to lottery sales tickets, the number of tickets, the prices, what you can sell, all that
So
stuff.
you're saying that even if we were to accept all the hearing officer's factual conclusions, findings, your view of the statute is neither section 26 nor 27 would allow the commission to withhold a license.
Exactly, and I understand the tension, but for example,
It may undercut your interpretation of section 27.
My client, with all due respect, should not have been subjected to the section 27 meat grinder that he.
Wait, I hear you saying that, but I just want to make sure I understand why. So what is your response to the argument that "and" can be read in two different ways? You're reading it one way, where it's this and that together, and then there's another way to read it, right? Do you see that there's another way to read it, that the commissioner can say you can't have it if you have a felony, and the commissioner can say you can't have it if you are a bad moral character? Do you get that there's two ways to read it?
I only see one way to read section 27 with regard to the felony conviction, which my client did not have, which is if you are.
I understand that that's your
Yes.
understanding of the, but are you open to the idea that it can be ambiguous, that there can be another way to read it? Are you saying no, there's no other way to read it?
Perhaps I do too
You
much.
seem so, why are you so frustrated?
No, I'm not frustrated. The frustration stems from, I've got a gentleman who I understand he was indicted. He went through this, and it might go to my vagueness argument, Judge. He gets accused of something horrible.
Right.
He goes to court, presses his case, presents his, he presents evidence in his own.
So I understand all of that, and I understand that he does not have a felony conviction, and that's not just in dispute. Right, we're right now just looking at the regulation and looking at how to interpret that.
Right.
So,
In the hearings, the Lottery Commission rested their decision to deny him his licenses based on 213 Section 7, which talks about we're going to, and I suggest that regulation is very contrary to the explicit language of Section 27.
I'm sorry, we're looking at Section 27,
Right,
and it
section-
has that "and" in it.
Section 27, convicted of a felony and determined to be of deficient moral character, you don't get your license. That's what the statute says. That's not what Mr. Zafar went to the Lottery Commission with.
Okay, so your answer to my question is that, as far as you're concerned, it is clear
Yes,
that that's what the statute means,
yes, Judge.
and there should be no more discussion about it. I understand your where you are on that. I get it. if we don't agree with you, where does that leave you? Because if the statutes, you know, if it can be read in two ways.
Well, if it can be read in two ways, he's still entitled to a hearing where these factual findings that I've been assuming is correct for the sake of the hypotheticals was supported by substantial evidence as that has been defined in the statute as well as by cases. And I understand that Covell talked about the idea that the investigator in that case who did an immediate investigation, and I use that term very decidedly, spoke with the complaining witness, spoke with the mother, spoke with the defendant, spoke with the guidance counselor, and then presented all that information in hearsay fashion to the hearings officer. That is just fundamentally what did not happen in this case. We had an investigating officer. His investigation was to accumulate documents and to present the documents to the hearing officer. You have a read of this, and the premise was that the defense kind of pulled a rabbit out of the hat, that this gentleman should have been convicted, but he wasn't. And in our opinion, just reading this, we think he had done it.
Excuse me. So aren't those just two different forms of hearsay, right? The Covell investigator presented hearsay in the form of their investigation, and then the investigator here presented hearsay in the form of extensive documents?
So when I read Covell, it says you can rely on some transcripts to make some credibility determinations. But this hearings officer made an entire, it wasn't simply the credibility of the complaining witness that he was assessing in this transcript. Recall, as well as the doctor testified at that hearing, recall that the first complaint witness testified, recall the police officer, and even the defendant's own witness, Ms. Sheila Schmuck, testified at that trial. So it's not one individual's hearsay, one individual's credibility compared. He's assessing like 5 credibilities on a written record where no one from the lottery had ever sized up one of them, looked at one face to face and found out whether or not there were anything within their presentation that called into question what they were recounting.
But it's substantial reliability, right? So what you're talking about was their trial testimony.
Right.
And all of those witnesses were subject to cross-examination
Right.
by someone representing your client who had a vested interest in bringing out anything that would be helpful or that would be hurtful to the Commonwealth's case. So why isn't the hearsay that was relied upon in 2 dimensions substantially reliable because it went through that process?
Because it is not often what a witness says, but how they say it, their frankness or lack of frankness. We've got a written transcript with inconsistencies galore, but what the investigator never spoke with a prosecutor. What happened in this case? The investigator never spoke to the complaining witness. What happened in this case? They're doing on a cold written record and saying, well, we read it and we think the jury has it wrong. We think we're right.
Which Cavell says can be done.
Cavell is in real tension with City of Salem, Judge. It's in tremendous tension with City of Salem. City of Salem was the case where the police officer, civil MCAD, I was discriminated against. Police chief, no, he wasn't. They testified to the hearing officer. He retires. He leaves the case. A different hearing officer reads the transcripts, makes a decision. I credit the officer, can't do it. Covell comes along and says, well, if you begin giving oral testimony, you have to hear it. But otherwise, you can read a transcript. This is a he said classic, the allegation, classic he said, she said, no forensics corroborated in any which way. And Covell, to the extent that Covell would suggest that City, whether it's on a transcript from the day before or a year before, it's still a transcript where under City of Salem, trying to resolve a contested issue, a material issue too, not a tangential or a corroborative element, but the heart of the accusation on a cold reading of a transcript. I think that Covell, to a large degree, to the extent it tried to carve out an exception, was simply inconsistent with the fundamental holding of City of Salem and our fundamental understanding of how we assess credibility, which is to assess the presentation of the person giving the testimony, giving the account. It just, Covell, and moreover, and I understand it's different forms of hearsay, but at least in Covell, they were doing some work. Moreover, Covell was decided in the circumstances of DSS, interim findings, right? In Covell, it was whether or not there was a reasonable cause to believe that some abuse had happened. And that finding was an interim finding to avail services for the child. It wasn't a final determination that the gentleman in question did what he did. That would be subject to further, I believe there's further procedures within DSS. So when Covell was decided along those lines, it was an interim determination. Here we have a final determination by the lottery that my client is the very rapist that he was accused of. And then relying on that acquittal to say he's of deficient moral character under Section 27, when and means and, we know what and means. Just that and means or, it opens up to more, or that we can draft a regulation that is contrary to the explicit fundamental language of the statute, I suggest was inappropriate in this case.